Hello, welcome to our weekly live attorney chat. I'm attorney Desiree Koger-Gustafson. If you are new to our firm and new to these weekly chats, we usually regularly come on here to discuss things that are happening in the immigration world, concerns that we're hearing from our consultations, just to kind of give people some information about the immigration process and what we're seeing from immigration, that world today. If you are watching us live, please feel free to comment. If I see the comment, which I do try to get on there to see those, and I can answer that question, I will do so live here while we're talking. If you're watching it on replay, please comment #replay. You can also comment and ask questions later. We do get those. Sometimes we'll reply if we can. Other times we will just do a whole nother video just based on that question, depending on what it is. So today I want to talk about the top 3 reasons that we see a green card be denied. And this can be just from, there are a whole host of reasons, right? These are just 3 very general reasons that I am seeing or that we are seeing here at our firm. Again, we regularly practice in immigration law, just assisting couples and their family navigating that immigration process. So we are really involved in the couples-based, so fiance visas, spousal visas, getting them here, getting them adjusted to getting their green card so they can travel and work and all of those things and start their life really here in the US. So our topic of discussion today are the top 3 reasons that we see green card denials. And the first of those would be that the application either has mistakes or you're ineligible for some reason. So you're not even eligible for that benefit that you are applying for. And so the adjustment of status or that green card can be applied for either in the United States or it's applied for through a consular post. So both of those will have the same requirements, but it's a little bit different of a processing nature. And of course, it's different trying to process that through another country. But one of the most common things that I see that people then come to our firm with a consultation for is that they've had some issues with mistakes that are made on the application, or they just were not eligible yet for that adjustment of status, which is the green card application. And so we really work to make sure that the applications are as correct and as perfect as we can make them in that initial stage, because whatever gets submitted to USCIS is going to come back later. So you're going to have to be able to answer for those discrepancies. Sometimes you can satisfy them. Sometimes they're harder to overcome once you already have an application or a denial or a mistake that's been made that we then have to correct. So that would be kind of the first, is you're just not eligible for that application or relief, immigration relief, or the application has mistakes on it. The second most common is the failure to even meet the application requirements. So you're eligible for the application, you're eligible for that green card, but you don't meet the application requirements. There's lots of forms. All of those forms have to be supplemented by evidence, of course. Fees, sometimes you need original documents. Not to mention the legal requirements of an adjustment of status or a green card application. It's just a lot. Many times USCIS will give you the opportunity to correct some of those errors, but I've actually seen people get denied after they've sent in subsequent information, after they've received a request for evidence. And part of that was because they just missed one line of something that USCIS was requesting, and they didn't send that in. And so then they end up with a denial for that green card application. So failure to meet the application requirements, and that could be fees. If it's a fee issue, usually they will send you back your entire application, and then you can correct that. But again, not always, and sometimes the missing application pieces come after you've already received a request for evidence. Probably the third most frequent or top reason that we see green card denials are inadmissibility issues. And that's kind of a big, broad word that is under the INA, but it could mean a lot of different things. It could be a criminal related issue. It could be an unlawful presence related issue. And sometimes people aren't even aware that those might be issues if they haven't discussed it with an attorney. Probably one of the most frequent that I see that causes a little bit of issues, but that we are able to overcome on a regular basis is the affidavit of support or that public charge inadmissibility issue. So it's making sure that the petitioner or that relationship, that person that's kind of sponsoring that relationship, makes enough money to support that extra person in their household. This is something that we do regularly see. I would say it's probably the grayest area that we see in our firm in immigration with that just green card application that you really can talk through and come up with a good plan and usually be successful in that arena. So I hope this has been helpful. Again, if you think that you might know someone who this video would assist or be helpful in their journey, please like, comment, share it with that person. Obviously, share our webpage as well, www.immigrationforcouples.com. If you click on the resources tab, we have lots of different videos that can assist people with various parts of the immigration process. Thank you so much for joining us.